Good evening, everybody. I must thank all of you for spending a Friday evening listening to a lecture on corporate fraud. Before I go further, I must tell Sucheta, Dalal and Debashish that they have mentioned some astute lawyer who asked 6 questions. May I make an RTI application and know the name of that lawyer? This lecture was, as Sucheta Dalal mentioned, was being postponed from time to time ever since the Sahara judgment came. And I could not speak earlier because I was busy with the 10th edition of Kangan Palkewala's income tax, and I kept postponing this particular lecture. In fact, I had stopped going to most of the high courts so that I could devote more time at the last stages of the book. Finally, this lecture was fixed on January, and by a happy coincidence, the book also was ready by December. So she suggested, why not have a book launch? And I was quite not very sure about it because, except that Courtroom Genius released, none of my books had a book launch as such. And perhaps people in Chennai are more shy about these book launches and so on and so forth. My senior told me that lawyers are supposed to be shy people. And even today we hesitate going before the television. Not anymore. Before I start the lecture, Mr. Bapu Malcolm asked me to first tell the audience, what does one mean by fraud? He said, your topic is corporate frauds, but what do you mean by fraud? Well, I never thought about that. I thought all of us assume that we know what is fraud. But I think it's an important point he raises. You know, Victor Hugo always said that when you speak, define your terms. Now, as far as fraud is concerned, sorry to be slightly legalistic, but I'll answer his question. Fraud is defined in section 17 of the Contract Act and consists of 4 components. First is suppressio veri, suppressing the truth. When is fraud practiced? 1, if you suppress the truth. Second, suggestio falsi, you make a false suggestion. The third ingredient in section 17 is making a promise without intention of keeping it. That is fraud. And the last is an omnibus clause, any other act fitted to deceive. Any other deceitful act is fraud, because as one law lord said, one cannot anticipate or one cannot limit the human ingenuity to commit more and more types of fraud. And interestingly, the explanation to the section says, whether silence amounts to fraud, and the answer is silence will amount to fraud if there is a duty to speak. So this is the meaning of fraud: suggestio falsi, suppressio veri, breaking your promise, and any act fitted to deceive. So I think I have answered your question. Now let me go straight away to the subject. After practicing for 3 decades, one thing which I was repeatedly struck was the enormous delay in bringing the guilty to book. One almost paid a premium on defaulters, and I kept asking the question why. I've been addressing seminars, making representations to the Law Commission and so on, but with little avail. Before I come to India, I'd just like to tell you a short story. All of you must have heard of Rajat Gupta, who was the first non-American president or managing director of McKinsey and Company. And if you read his life, it's almost a fairy tale. He was a person who was orphaned. He went to IIT Delhi. He went to Harvard Business School, joined McKinsey, and in 1994, he became the president of McKinsey, or the managing director of McKinsey, at just 48. He ultimately left McKinsey in 2007. And if you read his life, he seems to be an all-rounder, brilliant at academics, in dramatics, student leader, a spectacular achiever in every sense of the word. But 3 phone calls just 3 phone calls, finished his career. After 2007, Gupta was on the board of Goldman Sachs and Procter & Gamble and various other companies. He was also the founder of the International School of Business. He was in various charities and trusts. He was a personal advisor to Bill Clinton and Obama and so on. A charmed life. In September 2008, he attended a board meeting via conference call with Goldman Sachs, and he learned that Warren Buffett was going to invest $5 billion in Goldman Sachs. Warren Buffett's company Berkshire Hathaway was going to invest $5 billion in Goldman Sachs. He got this news at 3:45 in the afternoon, and all of you who watch CNBC other program know that the New York Stock Exchange closes at 4 p.m. every day. 16 seconds after he put the phone down, he makes a call to Rajaratnam. They speak for about 45 seconds to a minute. 2 minutes before the stock exchange closed, Rajaratnam places an order to buy wants to buy 300,000 shares of Goldman Sachs just 2 minutes before the exchange closes. He is able to get only 200,000 shares. And Goldman Sachs makes the announcement after 4 p.m. Normally they make the announcement after the exchange closes that Warren Buffett, the legendary investor, is going to put $5 billion into their company. The share price goes up by almost $4 per share overnight. Next morning, Rajaratnam sells the entire 200,000 shares and makes $800,000. Second phone call. This time it is in October 2000, 1 month later. Again, there is an audit committee conference call with Gupta. He's a director, and he's told that for the first time in the history of Goldman Sachs, the company will make a loss. It has never happened before. 23 seconds later, he calls up Rajaratnam, and they speak for 13 minutes. Out of the 3 phone calls, only 1 was recorded. He speaks for just 13 minutes to Rajaratnam. The same day, Rajaratnam sells. He had remaining 150,000 shares earlier. He sells those shares. Next day, the announcement comes that Goldman Sachs is going to have a quarterly loss. The share prices drop. This time, Rajaratnam doesn't make a profit. He avoids a huge loss by selling his shares on the basis of presumably this information. And the final killer was in January 2009, when Rajat Gupta, like so many industry leaders, is in Davos as they call it, the World Economic Forum, which is again going to be held from 22nd January to 25th January this year. This time he gets a call he has a conference call with Procter & Gamble's board of directors. He gets the news that Procter & Gamble is going to do badly that quarter, whereas the market was expecting Procter & Gamble to report huge profits. The reality was just the opposite. He puts the phone down, but calls Rajaratnam 4 hours later. Rajaratnam has no shares of Procter & Gamble. He sells short. He sells shares which he doesn't have. Next day the announcement comes, the prices crash. He makes a profit of a couple of $1 million. That finished Rajat Gupta. Ironically, the prosecutor was Preet Bharara, who is now in the news because of this Devani Khobragade incident. They totally launched 70 prosecutions, 70 cases, and 55 convictions took place. But the point for today's talk is the trial of Gupta started with a charge sheet in October 2011. The trial starts in October 2012, and on the 8th of January 2014, just 1 year and 2 days before, he's sent to 2 years in prison. That's the speed at which the conviction takes place. And this is not an isolated example. If you study these things, these subjects, you'll find Jeff Skilling, for example, who was the Enron managing director, also a very flamboyant personality. His trial started in January 30th January 2006, and in May 2006 he is convicted. A month later he is sentenced to 24 years in jail for the Enron scam. Ironically, Fortune magazine 4 times made Enron as the most admired company, but this is exactly what happened. But the point I'm making is this is the way in which people are convicted, which perhaps prevents so many other persons from following that particular path. Now let us come to Chennai. In the 90s, you had large number of non-banking companies. Now typically non-banking companies basically financed motor vehicles, scooters and things, assets like this, which are perhaps too small for the banks and too big for the pawnbrokers. So they require non-banking financial sources who can easily deal with the non-organized way in which the motor vehicle sector, the truck market operates. But as the non-banking companies grew, you had specialized non-banking companies who got into teak plantations. We had the famous Anubhav teak plantation where you invest money, they plant teak trees on your behalf. And the point is that by planting 10 saplings of teak trees, you will get, after 10 years, huge teak trees which are expected to sell at several thousand rupees per cubic meter, and you will make money. This was Anubhav Natashan's thing, and believe me, he had more than 1 lakh investors who bought the teak plantations and the investment. Then one person had a goat teak project. You pay 1,000 rupees, he puts 5 saplings and buys a goat. So these kind of combinations came on. And we also have a system, I don't know if you had in Bombay, we got Nidhis, which is a peculiar legal entity in Tamil Nadu, where basically it's a mutual association, Nidhis, like for example the Palghat Permanent Fund, the Mylapore Nidhi Fund. What they do is, they're basically small savings institutions which are mutual. So if I want to raise money, say for my daughter's marriage or some other program, I'll pledge jewels, take money on interest, and if you see basically Nidhis, they can't go bust because they give 75% of the jewel as security, so security always more. But the plus point of Nidhis was the ceiling limit on fixed deposits did not apply. So they could give 18% interest, 20% interest, and we had the biggest Nidhi, the Roypeta Benefit Fund, RBF as it was called, which raised 440 crores in the 90s from 1,92,000 depositors, 1,92,000 depositors. I know because I was later, when the company went bust, I was the government nominee director for some time. So this was the kind of company. Now you're supposed to use this money for mutual benefit, a family need, education and so on. But here was this Nidhi financing distilleries and breweries, financing 5-star hotels and so on. Look at how the regulation system works. In September 2009, RBI makes a complete check of this organization and says everything is fine. And on the 5th of November 1999, the company goes bust. Now, in Madras, 1,100 crore rupees were lost by depositors. 4 lakh depositors, so let's say 4 lakh families, saw their savings wiped out. And I remember as a director of RBF, we used to get heart-rending letters saying that my husband died in the Kargil war, I urgently require money, somebody wants money for a leukemia, chemotherapy and so on and so forth, and there was nothing we could do without the court's permission. But the point is, 1,100 crores were lost, 4 lakh depositors, and an avalanche of company petitions in the High Court asking for relief. What did the High Court do? For the first time, we had a wonderful judge called Justice Jayasimha Babu, who made lawyers as administrators because the liquidator could not handle the volume of work. So lawyers became administrators and they worked with the liquidator to recover money. And I'm happy to say that many lawyers did a wonderful job. In some companies, they were able to get 100%. In Mercantile Credit Corporation, where I was the amicus curiae, we returned 60% in the rupee, 60 paise per rupee, and so on. But many companies got nothing at all. Keeping in mind the magnitude of the fraud, the Madras High Court started what is called the Economic Offences Wing, EOW, somewhat based on the Serious Frauds Office in Scotland Yard, saying that economic offences are special. Most police people know to deal with theft, rape, murder, etc., human body offences, but this is a separate genre, so we require specialized people. There was a police academy, In the police academy, myself and some colleagues, we gave lectures on company law. Chartered accountants were brought in and they taught the police officials the basics of accountancy.